Good morning, everybody. This is Mark Rogers and Roman Hoynatsky. We're here for our second annual Q&A session following our 2022 annual client event. We hope you all had a great holiday. Joe, have we got any questions yet?
Not yet.
Not a surprise, just like last year. So Roman and I sat around and thought about some common questions that we get from our clients from time to time. This is one that's been coming up this year quite a bit, and that is sometimes our parent is having a little trouble managing things. One of the kids is named as an agent under a power of attorney, maybe not yet a co-trustee, and they go to the bank. And at the bank, they bring the power of attorney for finances, and they say, "See, I am the agent, Mr. Banker." And the bank says that you've got the wrong document. And then we're confused about why that's so. And for those of you for whom we have done the flow chart drawings, if you were to look at that drawing, you'd see two orange boxes that describe certain assets. Those assets are IRAs and 401ks, annuities, and life insurance. Those are always owned individually, and that's what the power of attorney is for. Usually the bank account is going to be titled in the name of the trust, and the power of attorney has nothing to do with that. So if you're having trouble getting control of that bank account, sometimes you can get the bank to agree that your mom or dad as trustee can appoint you as an agent. Other times we're just going to need to do an appointment of co-trustee and then have you return to the bank to gain control. So that's one of the most common questions that we've been getting this year. Do we have any questions yet, Joe? Not yet. So all right.
I would add, if you are going to the bank with parents or someone that you're an agent or trustee for, it's always a good idea to double check on the status of any safe deposit boxes. We have had several situations in the last year where after a death, there's been a great deal of difficulty gaining access to a safe deposit box. And we have a couple solutions to that problem. One is if the account is a trust account, then you should make sure to rent the box in the name of the trust so that successor trustees will be able to gain access to that box. That's one solution. If you have a plan that doesn't involve a trust, or you want to go a different direction, make sure that someone has authority to enter into that box on your death. And you want to specifically ask the question to the banker you're dealing with: if I pass away, will this person still be able to get into the box without any further difficulties? And that is something that should be able to help facilitate things if you still have a safe deposit box.
What is the process for getting someone declared needing special care due to dementia?
Well, I would think I can think of two things. One is we have tried to address that in your plan. Who says that I am not well enough to serve as trustee or agent? And what we typically do is require the agreement of your primary care or treating doctor and your primary healthcare agent. Those two individuals would sign what amounts to a one-page document that says that you're not well enough to manage either money or property or healthcare decisions. If you don't have any documents in place, or your documents are somehow inadequate, and I'm happy to say we most often see this in plans that we review done by others, then if there's a failure of that document to properly name a procedure, we may need to have a court guardianship. So you have to hire an attorney, petition for guardianship. Often the person who you're trying to get the guardian for will be appointed a guardian ad litem. That is by far a more complicated and time-consuming process than having it done correctly in your documents. Hope that answered the question. Rowan, did you have anything to add?
Well, I just think that it it should be looked at from a standpoint of whether the individual just needs help, or is what we would consider to be legally incompetent to make decisions. Because if the person that's in failing mental capacity is still aware enough to appoint someone to act as a co-trustee or to sign legal documents, it may be advantageous to review that before having an actual declaration of incapacity made, because that can sometimes be the point of no return. And when it would be necessary to do that would be in a case where the individual may be making unwise financial decisions, being susceptible maybe to elder abuse. Well, in those situations, you definitely would want to take the step of having a formal declaration of incapacity. But if they're just failing, not quite having the capacity they had in the past, it may be a good idea to check in with us before a formal declaration is made to make sure that the plan is in good shape, because after that declaration is made, we may not have as much flexibility.
I should say that if you feel like we haven't fully answered a question, feel free to call our regular number 414-289-9200 and ask Patty for just a 15-minute phone consultation so that we can address your questions.
For trust protector, could you review again who we should consider to designate for that role?
Yes, I'll be happy to do that. So we typically leave that in the drafting, we leave that open, and we leave that job to the attorney for the current trustee. And we feel that adds a great deal of flexibility to that process because the attorney is usually the person who knows whether something needs to be fixed. And so instead of going to court, you can use the trust protector. The trust protector appointer, who is usually us or whatever attorney your family happens to hire, will often appoint themselves because they have the skill and knowledge to fix the problem with an amendment. Now, failing that, you may have a trusted advisor who is willing to serve in that role, and you can designate that individual right off the bat in the document if you wish, and we are happy to always take care of that for you. I'm going to wheel out one that came up last year, and it comes up every year, all the time. We can't seem to persuade our friends in financial services that this is so. So your financial advisor says, wow, you've named a trust as the designated beneficiary of your IRA. You really shouldn't do that. If you want those kids to be able to pull the money out slowly and not have to take it all at once, the smart thing is to name each child individually. And I would say first that it's good that your financial advisor is paying attention to that and looking out for you. But in our plans that we've done for you, there's language that allows us to name a trust as the beneficiary and have the same rights and ability to pull the money out slowly that you would have if that individual was named personally instead of naming Jimmy's trust if you name Jimmy.
And just to follow up on that, if you have a surviving spouse, your IRA beneficiary designation normally, in most cases, should be your spouse first, and then the trust would be the contingent beneficiary. That gives us the most flexibility in post-death administration. Well, one of the things that does come up is how often should I have my plan reviewed by your office? And one thing that I've had several clients contact me over the last few months deals with planning for retirement. So they're currently working. They've notified their employer that they're going to be retiring as of a certain date. And at the time of retirement, if you're fortunate enough to be a participant in a pension plan, you will be given a one chance at the time of retirement to name beneficiaries of your retirement plan if you die before a certain period. Now, certain private pension plans are limited into what benefits continue upon death. But state retirement plans also have an option that you can sign up for a number of guaranteed payments. So you want to make sure that when you fill that form out, that you have the beneficiaries listed properly. So that's one thing I've seen that's come up over the last year a few times.
Scott asks, do you have any comments on the updates to the Secure Act that were recently released?
Yes, actually, you should know our program covered that. But let me go ahead, and it's not that hard to spill it out. The IRS, for reasons that are a mystery to us, waited a couple of years to clarify what should happen to an inherited IRA account. So the regular plan participant still is required to take what are called RMDs, required minimum distributions. They up the age to 72, so nothing's changed there. But what they changed is if you, as the owner of the plan, pass away and now have left that plan to one or more of your children, either outright or in trust, the question is, how fast do they have to pull it out? We believed until a couple of months ago that everybody had a full 10 years and that they could pull the money out on the last day of the 10th year if that's what they wanted to do, as long as they got all of the IRA money out in that 10-year time frame. What we've learned is if the plan participant, your mom or dad, who's now passed away, was already 72 and taking RMDs or required to take required minimum distributions, then you too, in pulling your money out over the 10-year time period, have to take out what are called RMDs based on your life expectancy. So if you're 40, you're going to pull it out more slowly than a 60-year-old. And that applies for the first 9 years. So you have to take a required minimum distribution in year 1, 2, 3, 4, all the way to 9. And then in the 10th year, whatever the balance is in the account, you have to pull the rest out. Now you can always pull out more. And I can tell you that it's often wise to pull out more. If you've got a $300,000 IRA that you're receiving and you're 45 years old, you're not going to be pulling much out in those first 9 years. So you might want to pace that out so that it's more evenly spread over that 10-year time period. This is an issue where you would work with your financial advisor and your tax people to make sure that you're not pushing yourself into a higher bracket on the withdrawals that you're taking. So the big change in the rule, to summarize, is instead of being able to take it out anytime over the 10-year time period, if your parents are taking their required minimum distribution when they pass away, then you must take a required minimum distribution in years 1 through 9 and take out the rest at the end. Hope that answered the question.
Next question. I made changes to my distribution list. Do I need to get this officially entered into the plan? I was told only need to date the document.
Roman and I may have different answers there. I highly recommend that you do a formal amendment, and it should be signed in front of a notary public. It's really dangerous. You may not realize exactly what you're doing when you're making a change. Changing beneficiaries is usually a pretty easy process. It's a percentage of what remains in my estate, or I want to give somebody $10,000 as a gift. But there are different places to put that, and sometimes different income tax consequences, depending on where you put it and what you said. So it's always best to get advice. It's pretty easy. You can, if you want to draw it up, sign it, date it, and send a copy to us to look at. We'll tell you whether we think it's okay or not. But many times we'll recommend that you go ahead and do a formal amendment.
And I agree with Mark's answer, unless we're talking about an item of personal property at the end of your trust booklet or binder. If you have a will in there, we do give you an opportunity to list beneficiaries for tangible personal property gifts. And those, you're always free to fill those out yourself. And the tangible personal property is limited to those items that you can basically touch and handle. So it's really better to have us review anything dealing with financial accounts.
Yeah, and I didn't mean to be confusing. Now that I realize what Roman just said, that may have been what the question was. It may have been about personal property. And we did tell you that all you have to do is list it, sign it, date it. And if you're giving your wristwatch to somebody, that'll do the trick.
In Stacy's presentation, where you have to private pay your assisted living for 2 years before going on Medicaid, how are you able to give the $214,000 to your family up front?
You have to liquidate whatever the assets are so that they can be given in the form of cash. And then you transfer ownership of that money and property to the kids. Sometimes we'll put it in an irrevocable trust to help protect it from the claims of creditors of the kids, or if a kid goes through a divorce, it protects the money. And so that money, there are two components to this process. One is first we make a gift, and we're talking about single individuals. We make a gift of the money, and then we have to apply for Title 19 right away, have them say, except for the fact that you made a gift that creates a penalty period, you otherwise would have been eligible. That starts the clock running on the penalty period, which is just a waiting period. So the money that gets protected in that transaction is the gifted money. And usually there's a loan that's made in connection with that the kids will pay back month by month, or a purchase of a special annuity that will pay month by month back to you while you pay your assisted living bill as a private pay patient until your penalty period runs out. Now, this subject we know is very confusing and it's really not that easy to understand. So we're delighted to help you if you have further questions about that.
For the inherited RMD distributions, is the RMD amount based on the inherited person's age or the deceased's age?
That's easy. It's the inheritor's age. So if you're a son or daughter and you're 45, we use what's called the single life table. And there's a little entry that says if you're 40, here's the percentage that you have to take out. And then it's a countdown from there, subtract one from the percentage until it gets to 0. So the younger you are, the slower you can pull the money out.
How often do you recommend that an estate plan be reviewed or updated? 4 years? 5 years?
So there's, I'm going to answer with some general happenings that would cause a review, and then I'll get to the year question at the end. So if you have a major change in life circumstances, a health issue, maybe a marriage, birth of a child, divorce, retirement, those types of situations should cause you to have a review at that time. Now, if there's a major change in law, normally this program, when we announce it on an annual basis, the letter that we write will highlight changes in the law that may impact you. So by attending this program, you may be clued into a reason to call in and have a review. But if none of those circumstances present themselves, we use a guideline of about 3 to 5 years as a time period when you should come in and have a plan reviewed. But we learned during the COVID shutdown how easy it is for us to answer questions without needing to set a 2-hour appointment in our office. And we're certainly happy to have you call and schedule. And Patty, who you'll normally talk to first when you call in, she's very good at determining how much time you need on our schedule. If it's just to answer a quick question. Sometimes people just call up to see, do I need a more detailed review? So if you have any questions at all, it's safer just to call and ask. But if I had to give a blanket year time period, I'd say from 3 to 5 years. And normally it's the older that you get, the shorter period of time you should probably have between reviews.
I guess the one thing I would add is what Roman was saying in a different way, and that is there are 3 things that are going to change over time. You and your family circumstances are going to change. That's health, retirement status. It could be your kids. Your daughter Jane is going through a rough spot in her marriage, and you're worried about her husband Scott having any chance of getting at the inherited money. What do I do about that? So that's family circumstance change. And then, as Roman said, the law changes from time to time. And then the third thing is us, the lawyers. We're constantly going to programs, learning new techniques, new ways to get things done for you in a much more efficient fashion. We do the best we can when you come in, but there's no time limit on possible improvements.
Do old memorandum lists ever expire? When a new list is drafted, does the old list continue? How do old lists get canceled?
Rip them up, cross through them, put a big X in it. And then usually we go by the most recent list, and there's language in the trust that says if the list conflicts with what's actually said in the trust, sometimes somebody wants to designate a diamond ring to a particular person. Then they talk about all their jewelry in their personal property memorandum. So it'll say the trust controls over any discrepancies.
So I have a little different take on the cross through. Those sheets of paper, if you run out of them, we're happy to send you more. You can make a photocopy, but I think that it can cause controversy to cross out something or cross out a family member's name and change it to another person's name. It just may raise a question as to, what did I do to upset mom or dad on that date that all of a sudden my name was crossed off and my brother's name was put in there instead. So I think it's better to start with a sheet that is clean without crossouts and just start over if at all possible, just to avoid any controversy.
And I would say that I fully support Roman's answer. And we want to warn you about another thing. Roman and I had this experience. Not many people use these personal property memoranda, and they really are a useful tool. And we had one client who really made good use of it and did page after page. And one of the things that was written on that page was, and I'm not going to use the actual gender, it's going to say anything he wants. So in other words, this person who is named could select anything, including to defeat the other listed items for the other people. Fortunately, that did not blow up. So, but be careful what you write in there. You want to say a name and an item that they're going to get. That's the best use of that document.
How does long-term care insurance work? Which will pay a daily benefit through the lifetime of the insured, factor into the private pay Medicaid equation?
Well, usually long-term care policies will run no more than 3 years these days. You used to be able to buy a 5-year or a lifetime policy. And if you've still got one of those, hang on to it for dear life. But that is considered income support, and it may make you ineligible. A general rule of Medicaid eligibility is that your cost of care has to be greater than your income. And the long-term care insurance is counted for that purpose. So usually the best use of that long-term care policy is it buys us time so that we can give away assets. There's also a 5-year look back that I think some people know about. And if you get enough, have enough money to private pay with the addition of your long-term care benefit, you may be able to make a gift right away. of money and property to your family and get that out of your estate. So those are the things I have to say about that. Roman, anything?
Yeah, I think it's just great if you have such a policy. And Stacy does most of our Medicaid planning. She really has a lot more flexibility, and in the gifting situation, you're able to generally private pay and have a larger gift that you're able to give to family members without disqualifying yourself and ending up without the finances to pay through any penalty period.
Is it a good idea to add an agent's/adult child's name, and in parentheses, trust financial POA, close parentheses, to a parent's personal savings and checking accounts to make it easier to transition if the parent begins to struggle with managing their money or in the case of death?
Yes. And you have to realize, if you're naming an agent, the power that agent has will pass away when the person that named him as agent passes away. So if you want something more permanent, you're gonna need to make sure that person is a successor agent, or you could name them as a current co-trustee, and then have that extend beyond disability or death.
And if you don't have trust planning and you want the ability to use that account to extend past death, you can name them as an agent currently, and then you can have them named as a payable on death beneficiary, that upon your death, they are able to take that account over. The difficulty with that type of planning is that you may have more than one beneficiary, and technically those funds become that one individual's upon your death. So you have to take that into consideration when you're using payable on death designations. But oftentimes clients will name one child on a specific account with the understanding that the child will use those funds in that account maybe for funeral expenses or other end of life expenses that are that need to be dealt with.
Yeah, and you hope that there's an agreement among everybody in the family, because that can cause problems if mom or dad sets up a joint account with one of the 4 kids. It's legally theirs when mom or dad dies, and we've seen occasional, not very often, but some scrapping over, is that joint account to be included as the part of the pie that gets divided up, or does that just go to Susie, who's on the account?
This is a follow-up question. If a memorandum list from 1990 is located, is it still binding if we can't locate a newer version? A new will was created since that 1990 timeframe.
There, I'm going to say I don't know. Does the new will have a provision for using a personal property memorandum or not? In which event, I think that if it did, the original memorandum is no good. But we'd have to take a look at that situation. Be happy to do that if that's a question. But if you find an old one and you still have the same plan, it's just as good if it was done in 1990 as well as 2010.
If you had an old will and you did a lengthy memorandum, and then you had an updated will, you could just sign a statement saying that you adopt this list as still valid as of the date of the new will. Then you wouldn't have to fill it out again, a new one again. Or
say in the new will that you're adopting that older personal property memorandum. There's all kinds of ways to get at it.
No questions currently.
Did you have something to say?
Well, I do want to add something because of the Secure Act has somewhat disrupted the planning with IRAs. And one thing that should be considered if you have charitable inclinations would be to directly name the charity or charities of your choice as beneficiaries of an IRA, because that will have two beneficial impacts that I can think of right off. The first one is it's fewer funds that would go to maybe your children, that if they're trying to stay in a lower tax bracket or do tax planning for themselves, if they're adequately taken care of in other places in your plan, so that it's one less thing that they need to deal with as far as having that inherited IRA. The other benefit is, if you name a charity as the direct beneficiary of that IRA, they will receive the entire proceeds and it will not be subject to income tax. So it's a way to leverage your gift to a charity. The caveat here is that it's not the same as just naming that charity in your trust. And as Mark talked about earlier, where the trust sees through to the beneficiary, it has to actually, in the beneficiary form, directly name the charity, and then there can be that tax advantage involved. So that's one thing that if you're interested in leaving a portion of your IRA to a charity, that you should review with your financial advisor, or if you have any further questions about that, please contact us.